All right. Good morning, everyone. My name is Anthea Halligan, and welcome to our webinar. It's called Navigating Australia's Migration Strategy. So thank you very much all for joining us today. Now, just to let you know, we will get started in a couple of minutes, but we'll just wait for a few more people to enter the session. So we'll just give it another minute or two. So everyone, if you've got any questions during the Zoom webinar, there's a Q&A feature at the bottom of your screen, and we'll try to answer as many as we can at the end. You don't need to wait till the end, so please feel free to type the questions in as we go. As you probably heard, the webinar is recorded, and we will send you a link so that you can re-watch this if need be at the end of the session. So thank you for joining us again. I'm guessing that you've come along to learn a little bit more about some of the latest changes in Australia's migration space, which is ever changing, as you know, and how it may impact your business. So I hope at the end that you can walk away with some useful information. So slide 2 is just introducing you to Yvette and May, who are going to be our presenters. Yvette Gassick is the head of migration at the arm of the business called Citation Migration. She's got over 20 years experience and worked in all sides of immigration, such as assisting organisations in industries such as health, engineering, hospitality, logistics, to name just a few. May Liao is a senior migration agent with us, and she's been registered in Australia for almost 10 years, and she's specialised primarily in employment-sponsored visas across a variety of industries as well, industries such as IT, agriculture, childcare, sport and manufacturing. So a little bit of information next about Citation Group. Just the next slide. A bit. Perfect. So I know a lot of you do know the company, but if you haven't attended one of our webinars in the past, here's a little bit of information about Citation Group. So the group itself has been around for over 30 years, working to help Australian and New Zealand businesses by providing complete workplace compliance solutions that help create more efficient workplaces. From outsourced HR solutions and safety management systems, ICS certification, workplace law, and migration. Citation Group can support your business in one or all of these areas. So if you'd like to learn any more about our arm of the body or any others, please feel free to talk to myself or the team after today's webinar, and we can walk through all the different aspects of the business. So the next slide, slide 4. So our particular arm of the group is known as Citation Migration. For over 10 years, Citation Migration has been providing Australian businesses and individuals with advice, strategic assistance and practical solutions for all migration and citizenship issues. So if you're seeking any immigration services at all, we are here to support you on that journey. Please reach out. So next slide, I'll now pass over to Yvette and May. I'll come back a little bit later and answer some questions, but Yvette and May will walk you through today's topic. So I hope you enjoy the webinar.
Thank you, Anthea. Welcome, everybody. Thank you for joining us today through your busy schedules. We appreciate you taking the time to hear an update on this important area of law. So the agenda for today, as you can see there, we're going to chat to you today about the increase to the skilled visa income thresholds as it relates specifically to the 482 visa program. We'll also give you some recent examples and updates relating to the SID, which is the Skills in Demand 482 visa. We'll also talk about some fee changes that have occurred relating to citizenship, new restrictions on foreign ownership of houses for temporary residents, and then also mention a little bit about the new National Innovation Visa and what New South Wales is proposing in that regard. As Anthea mentioned, we're happy to take questions as you go along. So please feel free to put those in the chat, but we will be taking questions most definitely at the end as well. So we're going to leave some time for that. So let's get into it. Okay, so what are these increases in the income thresholds? Those of you who are familiar with the 482 visa program will be aware that in the past we've called it the TSMIT, which is the temporary skilled immigration threshold. That is sort of an average, if you like, salary that is set as being the base as an entry level point for this type of visa category. Towards the end of last year, as you'd be familiar, the 482 visa was renamed the Skills in Demand visa, and the threshold was increased to the 73,150. What's actually happening on the 1st of July is that threshold is now increasing to 76,515. And as was advised towards the end of last year, year on year now, on the 1st of July, we will see that these income thresholds will be increased, usually in line with CPI. So this new salary threshold will apply to nominations under the core skills stream. You might remember there are 3 streams now under the Skills in Demand visa. This is that middle stream that majority of applications often are in. And so it's the threshold that sits between, it's the 76,515, and then the previous threshold of 135 for the specialist skills is now going to increase to 141,210. So for those applications that have the salary thresholds at 76,515 to 141,210, you'll sit in that core skills middle stream. And those applications that are with a salary threshold of 141,210 or above, they will sit in the specialist skills stream. The key thing to note is that this salary change will apply to those nominations lodged on or after the 1st of July. So what does that mean? As I've said, you'll need to meet this new updated income threshold from 1 July. Any existing visa holders that currently hold a 482 visa, these new salary thresholds don't apply to existing visa holders, only to nominations lodged after 1 July. The superannuation guarantee levy is also going up. And so, that was legislated some time ago, but from the 1st of July 2025, the current super guarantee is increasing from 11.5% to 12%. And so employers should ensure that any guaranteed annual earnings for their employees are not inadvertently reduced as a result of this superannuation rate change. As you know, the salary thresholds I was talking about just now exclude superannuation. So that's sort of what we call the base salary threshold. So anything that you're providing to your employees would be on top of that to meet the threshold. So what do we suggest in terms of action steps for you as employers? We would suggest reviewing your salary packages, ensure that the proposed salary meets or exceeds the new thresholds to avoid delays or refusals in your nomination process. So if you've got any applications that you're potentially looking for our existing clients to send across, for example, then you may want to make sure that those thresholds or the salaries you're proposing to offer employees are at those thresholds or higher. You may want to decide to lodge applications pre-1 July if you think one of your applications that you're considering is going to be on that threshold or not going to meet the new threshold. The second suggestion is to prepare for future applications. So if you, as I've mentioned, you may want to submit nominations prior to 1 July if you specifically are going to fail to meet the updated requirements. So that would be our key recommendation under these changes. Are there any questions on that at all? I can't see any questions in the chat at this point. Just having a look to make sure. Okay, all right. Well, moving on then, May is now going to walk you through some tips on the 482 visa. Over to you, May.
Hi, everyone. I'm going to cover some recent trends and some very important tips on the 482 visa. It's a skills in demand, the temporary employer-sponsored visa. That is also the most frequent issues that we encounter on a daily basis. So first, the consolidated core skills, skilled migration occupation list started from last December, 7th of December, has removed some occupations from the list from the previous short-term or medium-term 482 visa list, such as like childcare center manager is no longer there. But you may find the closest match for those under the old occupations if you want to move these employees to the PR 186 temporary residence transition stream, such as childcare worker. But the position description and the duties will have to be carefully assessed by a migration professional. Just make sure that they will align and meet the genuine position requirement. Second, the current focus from the Department of Home Affairs has some new changes compared to their previous processing. So first, there have been a rise in subclass, the training visa, subclass 407, nomination and visa refusals. So the nomination refusals of training visa mainly come from the longer processing time of up to 8 months. And the trainees may have already become overqualified and become eligible for the skills in demand 482 visa, which only requires 1 year's experience compared to the previously 2 years. So then they become overqualified and nomination ground doesn't hold. So there can be a nomination refusal. And the visa refusal may come from not meeting the genuine temporary entrant criterion, that the trainee candidate has been in Australia for a long time, for 5-6 years, and holding a series of student visas or other temporary visas. The GTE criterion has always been in the migration law, but it has not been taken that seriously before. So if you do have some training visas have been lodged and pending for 6 to 8 months, just feel free to reach out to us for further advice. The second trend about the Home Affairs focus is the market salary rate. So according to the immigration requirement that the equivalent Australian worker must be paid at least, the candidate must be paid at least the same as the equivalent Australian worker, on not offering less favorable employment terms and conditions. So that's the legal requirement. But can we move to the next slide? Yeah, but in our some recent cases, a global freight handling company who has been audited by the Department of Home Affairs has been questioned about the market salary rate requirement, just because they made a statement in the genuine position statement and also the form that other job applicants have higher salary expectations. So that has been taken by the Australian Border Force as an example of not providing equivalent employment terms and conditions and not meeting the requirement. So the hypothetical Australian equivalent workers are paid less than the sponsored foreign worker. And we have handled this audit and tried to explain for the client by saying that the job applicants are actually not Australians. So this doesn't hold. And there is a recent successful ART appeal case about the character requirement that Yvette will cover.
Yep, thanks, May. Yes, so this is probably a little bit of a different flavour in the sense that we also do appeal work, which you may or may not be aware of. So for people whose visas are cancelled and they want to appeal that cancellation, we can assist with review work as well as into the federal court if needed. The reason we've raised this one is really to sort of shed light on the importance of character under all types of visa categories. Character is an essential, what we call a public interest criterion that occurs, and that is that someone is of good character to be able to be granted the visa. What does that essentially mean? It's talking about things like prior criminal history or, for example, a police record check that may, for example, have a criminal charge or a period of incarceration. In this particular case, this was a very interesting one that we took on appeal. This particular individual held a New Zealand citizen visa, which is the special category visa that applies to New Zealand citizens, the 444 visa. And he'd been in Australia since he was about 14 years old. What occurred is his visa got cancelled. And why was it cancelled? It was found that he no longer passed the character test. What had occurred is he was found to have had a substantial criminal record because he was convicted of a sexually based offence involving a child, and he was found guilty of that. And so as a result, the minister cancelled his visa. What did that mean? Well, obviously, with a period of incarceration of more than 12 months, he was obviously in jail. He had to take it on appeal to be able to remain lawfully for the time of the duration of the case being heard in the country. So when we went on appeal, we were essentially saying that the visa should be reinstated, was basically our argument. And of course, the minister was arguing against reinstatement. What are the things that immigration looks at? Well, when a visa is cancelled, there is a direction that is provided, and the direction is set out in Direction 110. And that sets out a number of criteria that the department must look at when they decide to cancel someone's visa. And also for the court, that is the Administrative Review Tribunal, to decide whether they will allow the visa to be reinstated. So things like the nature and seriousness of the conduct. So they consider and give weight to, what is the offence, which is what they had to do in this case. The risk to the Australian community of that person's, if he's allowed to walk around, for example, if he had a history of violence, what is the risk to the Australian community? Is there a risk of reoffending? So in this case, where it involved an offence of a sexual nature, is he at risk of reoffending a similar crime? Then they look at the protection of the Australian community. What is the reasonableness test? What does the Australian community expect on a reasonable sort of scale as to how the Australian community should be protected? Then they look at, and they did in this case, his ties in Australia. So obviously all his family were here, and that was a very big consideration. His parents, he was a 20-something-year-old gentleman who'd lived in Australia, as I said, since he was 14. All his siblings were here. His mum and dad were here, and at the time of the offence, he was living with his parents. There was also evidence that was presented relating to his mental health. And so what the tribunal actually took into account was if he was actually sent back to New Zealand, which is what was being considered of him being deported back to his, original country of citizenship, what would that actually mean for him? Now, given the mental health of this individual who suffered quite significant anxiety, and, I guess his well-being would be impacted by being separated from his family, and what sort of rehabilitation was available to him in New Zealand. These were real primary considerations that the tribunal member took into account as to whether he decided to allow the visa to be, or the actual case to be reverted back to the department for the reinstatement of his visa, which was the 444 visa. Essentially, His impediments to removal were given quite significant weight in this case, because they found that his removal would be emotionally taxing and it would place an intolerable burden on his family as well as the individual, to return him back to New Zealand, where he had absolutely no ties and would be basically having to start again without any support, which this particular individual particularly needed. And so basically, considering all of that, it was found that the applicant would face exceptional difficulty re-establishing himself, considering his social anxiety, lack of ongoing support, and mental health conditions. And so the tribunal member placed significant weight in favour of revoking the cancellation, given the impediments the applicant would face without access to the support he currently had in Australia. So that's a success story. I guess that's a lot of detail, but I really wanted to highlight that character, even under the 482 visa and any other temporary visa that an individual holds, could be grounds for either not granting a visa if you've got a prior criminal record, or subsequently, if something comes to light, your visa can be cancelled. So it's important to be aware of these things. And I think it's highlighting the significance of character, and health is another one relating to public interest criterion that are taken into account. So that's another success story. So any appeal work that you may come across, we'd be happy to assist with. Moving on, May is going to talk you through citizenship, because that often comes up with some of our clients who are interested in considering citizenship. So maybe, May, if you could maybe talk about the difference between citizenship by descent and citizenship by conferral.
Yeah, absolutely. There are generally two kinds of citizenship application types. One is by descent and the other is by conferral. So citizenship by descent usually would be the children born to Australian citizens overseas, and they can acquire citizenship by automatically, but they will still have to apply for citizenship. And citizenship by conferral would be the permanent visa holders who have met the general residence requirement and having held the permanent visa for at least 12 months as of the visa approval, and they will become eligible by to acquire Australian citizenship by conferral. So there are also citizenship through adoption and other types of applications to evidence Australian citizenship. And post 1 July, the citizenship application charge will increase, but not too much. And there won't be any change to concessional fees or nil fee categories.
Excellent. All right. So the thing about citizenship also I'll mention there is character can come into citizenship applications either at the time of immigration considering someone's application for citizenship, so any prior criminal history. They can also take into account non-disclosure of criminal offences or any other incorrect information that was provided on any previous applications. So once you obtain citizenship, that doesn't mean if something comes to light at a later point that immigration cannot decide to revoke. That often comes up in cases where, for example, criminal activity occurs post-citizenship. So citizenship can be taken away. So that's important to note that character comes into citizenship in a big way. Moving on, we thought it would be important to mention some changes around home ownership, and this would impact anyone on a temporary resident visa. So since the 1st of April this year, the Albanese government introduced legislation that basically indicated that foreign persons, including temporary residents and foreign-owned companies, are banned from purchasing established dwellings for the next 2 years, so until 2027. Some of the exceptions to that ban include investments that contribute significantly to increasing housing supply or support the availability of housing on a commercial scale, or in specific schemes like the PALM scheme that some of you might be familiar with. The other exception to the ban is purchases by foreign-owned companies to provide housing for workers in certain circumstances. So that's something to be mindful of and important to consider. And it could be relevant for any visa holders that are on this webinar today. The other visa we wanted to talk about is this was also a change introduced towards the end of last year. That was that the National Innovation Visa replaced the Global Talent Visa that some of you might be familiar with. The subclass has remained the same. It's still called a subclass 858. The aim of this visa, which you might recall, is that it's aimed at attracting diverse, high caliber talent from various backgrounds, and it offers a unique pathway to PR directly for those who can significantly contribute to the Australian economy. The way you apply for it is by expression of interest, and in that expression of interest, you will nominate which state you'd like to reside in. Last week, the New South Wales State Government indicated that they're expecting to open their nomination program under the National Innovation Visa around the 1st of July. So New South Wales will open up this category of visa that can be applied for. And they have identified these key priority sectors for the next 4 years. And they will prioritise candidates who align with these 6 critical skill areas that New South Wales has identified. The first is in the construction space, so infrastructure and housing. The other is net zero and energy transition. The third is care and the support economy, so obviously in the healthcare space. Digital and cyber security, agriculture and agri-food, and finally advanced manufacturing. That's not to say if you're in other categories you can't apply, but what this advises is that these 6 areas or other priority sectors that New South Wales will prioritise in terms of providing offers to apply initially. And so we're looking at the 1st of July when this will open up. So obviously this is a visa that we're very interested in for our clients, and where we think it appropriate, it would be a visa that we would recommend clients to consider applying for. So we're right on the halfway mark, and we wanted to, Anthea, did you want to talk about this particular offer that we wanted to provide clients with who are here today?
Yes, thank you, Yvette and May. That was fantastic. So for those who have actually attended today, we have got your details. We're actually offering an exclusive discounted set fee on what we call a quick check audit service. So this is actually a great chance for your business to obtain a report on the current status of your complete foreign workforce. So what we can do is we can simplify and improve the accuracy of your visa audit process with a citation migration work rights check. So to get started, you can see that on the side that there's a QR code on your screen. If you click on that, take a photo of that QR code, a short online form will appear. And if you complete that today, you can also you can have access to this discounted audit service. And then, so basically, as soon as you complete the form, we'll then be in touch with you as soon as possible, and we can go through the next steps. So I might just give you all a minute now to actually scan that QR code while you're here and fill in the form, and then we'll jump right back in about 30 seconds or so. There's a couple of questions as well. We might move to those. So feel free to please add any questions you may have to the webinar chat box.
I have a question from Jennifer 2 minutes ago about the quote and onshore offshore options.
Yeah, Jennifer, what was that specific question? Could you give a little bit more detail?
The visa
Are they
category.
onshore and offshore candidates? Any possible quote for that service? Ah, I see. So I suppose you're asking, is there a difference as to whether the visa potential applicant is onshore or offshore? I'll let Yvette or May answer that.
I'm not sure what the question is asking, but if you're referring to the audit, perhaps, but maybe Jennifer can clarify. In the meantime, so
Okay.
when you say the 485 visa, the 485 is a graduate visa. The 482 is the working visa. So I'm not sure if that's what you're referring to.
482, if it's 482, 482 can be applied both onshore and offshore.
Yeah, whereas the 485 is an onshore only. Okay.
I might jump in while we're waiting for some others because it was quite interesting. May talked about this, how the department is refusing a lot of training visas based on what's called a genuine temporary entrant requirement. May, what sort of evidence or aspects would an applicant have to submit in order to meet that GTE requirement?
Okay, an applicant could provide evidence of proof of ties with the home country. Example could be the possibility to secure a stable employment opportunity in the home country, have family ties, financial ties by holding assets or bank savings in the home country, etc. But I think for training visa, we'd better be more careful because it's not just that simple because of the skills requirement already become during the processing time, a nominee training candidate already become overqualified. So it could be either nomination or visa refusal. So if you have any lodged training visa or you look to sponsor anyone for a training visa, better to discuss with that because it is more complex than before.
Thanks, May. Does anyone else have any? Oh, I think that one's been answered by Jennifer. And you talked, May, about a childcare centre manager not being on the list, and you could possibly consider a childcare centre worker. Do you have any other examples of similar situations, maybe in the corporate situation where
Yep,
an
definitely.
occupation's now been removed?
Yep. Another example could be the ICT support engineer, that most companies will have some in-house IT supporting the software and hardware and the system maintenance. That is an example of that classification is ICT support engineer, which has been removed from the new core skills occupation list. But there is an alternative ENSCO occupation called ICT tester and support engineer, not elsewhere classified, which they share a lot of common tasks and may be used alternatively, but it should be on a case-by-case analysis and would need to have a look at the position description and the organization chart for further assessment. Just
No,
open to that possibility. Sorry.
Thanks, May. That's helpful. I've just got a question here that's a simple one but very good. Yvette, does an employer have to offer an increased threshold of wages for any category of job?
Okay, so if someone already holds the 482 visa, you don't have to increase the salary to meet the threshold. So they're already holding a 482. You just continue at the salary level that was originally approved under, or if they get a pay increase, that's fine. As long as it doesn't go below the salary threshold that it was originally approved for. But in terms of increasing the threshold, as a result of the changes on the 1st of July, as I mentioned, it won't apply to new applicants post 1, sorry, it will only apply to new applicants post 1 July. Those that already hold a 482, it doesn't apply to. I hope that answers the question. So you don't have to offer an increased fee or wages, sorry, as a result of that.
Thanks, Yvette. No, that's clear. So another one related to the 482 visa, maybe May, if you could answer this. If a new skills in demand subclass 482 is refused, how long does the applicant have before this visa expires?
If the applicant is holding a bridging visa A by having lodged this 482, and the bridging A will be valid for 35 calendar days as of the visa refusal. Yeah, hope that answered that question. But usually they would not be able to lodge another temporary work visa because they have been refused 482 in Australia when holding a bridging visa. So it's called a Section 48 bar. So it would be a complex situation that they would need to depart.
Thank you. There's one other question here. It may be one that has to be discussed outside the webinar, but is the purchase of property by foreign companies for workers a risk of modern slavery?
Well, that's an interesting question.
Yeah.
Yeah, I think it's probably more of a political statement. I'm not sure we could actually answer that on this particular webinar, but happy to have that discussion separately if that's something that the individual who asked that would like to discuss. I'm happy to do that.
And then another one that's just come up is, does the new threshold, which is going to commence 1st of July, which is 76,515, 76,515, does that include superannuation?
No.
Doesn't. And what was the new super? So
it's going to be 12% from 1st of July. It's currently 11.5%. So you'd have to add that on top.
And after
35 days, they will have to. Oh, that was the question coming after the visa refusal.
Oh, that's May's, yeah.
Yeah, they can come back to their country of origin, their country of passport, or any foreign country. There is no limitation from the Australian immigration perspective, but they will have to leave before their bridging visa expires. So if you run a visa entitlement check after a 482 visa refusal, you will be able to find the bridging A's visa validity has changed from indefinite to 35 days after the date of refusal. That day is not inclusive. Yeah.
I think that's all the questions in the box, but we're obviously more than happy to answer questions if you prefer after the webinar. There is an email address on the slides there, migration@citationgroup.com.au. So please feel free to either give us a call or you may put some questions via email after the webinar, and we're certainly happy to respond in due course. And then we're excited to have a look at hopefully helping some of you with these quick work rights checks that could be really helpful.
Yeah, so appreciate.
Sorry,
I was just going to say thank you for attending. The immigration landscape at the moment is obviously quite buoyant. We're finding that our clients are asking lots of questions, particularly post-election. And so the program itself is still quite buoyant. And we're finding that a lot of companies are asking specific questions around obviously the skill gaps, and labour agreements is another one. And so for those in industries that are not necessarily on a list but have a need, the labour agreements are also an area that we'd be very interested to talk with individuals about, if that's something that is relevant to you in an industry where you think that you might not be able to sponsor, relating to occupations not on a list. There are other options available. We're happy to discuss that with you. If there's no further questions, we might close the session, and we really appreciate you taking the time to join us today. As Anthea said, please reach out to us directly if you have very specific questions you'd like answered. Thank you for attending.